Okay, a few housekeeping matters first. This seminar is being recorded. Amy, Rose and I will be referring to slides. You will be sent these slides at the end of the seminar, and you'll also be sent a recording. We do have the question and answer function available. Amy, Rose and I plan to take questions at the end. We've been rather greedy with the materials that we're looking at. So we've got a lot to get through. So I am going to get started with a brief introduction. First of all, Amy will be talking about domestic abuse and how the courts have been dealing with allegations of domestic abuse post-REHN. Rose will then talk about COVID and its legacy for lawyers working with international families. And then Rose will talk about surrogacy and assisted reproductive technology. I will then talk about parental alienation. Then it's back to Amy for section 9114 orders and transparency. And then I will conclude on themes emerging from recent Hague cases. So without further ado, I shall pass on to Amy.
Hello everyone. So yes, as Zoe said, the first section is going to be talking about domestic abuse post-REHN and how the court's dealing with these kind of cases and how to address such allegations when you've got a case like this. So these are the cases that I'm going to talk about, and then there's some guidance at the end, which I think is quite helpful. So K&K, in brief, this is a case that gives guidance on the proper approach to fact-finding hearings following HN. The background of the case is that it's a marriage that ended in 2017. Father had regular unsupervised contact with the children. The arrangements then subsequently broke down. And in 2019, the father issued an application to the family court. In mother's Form C1A, she made minor allegations against father, but she didn't object to father having unsupervised contact. And it was only in the safeguarding letter that it was recorded, her allegations against father of rape, coercive control, and the Kafka safeguarding letter suggested that recommended that a fact-finding hearing should be considered. At the Fahudra, the judge ordered a fact-finding hearing, and findings were subsequently made against father, including the rape, coercive controlling behaviour towards mother, and physical abuse of children. There was then an appeal, and the Court of Appeal found that the rape finding was unsafe. The judgment was set aside, and the case was remitted for determination as to whether a fresh fact-finding hearing was required. In the judgment, I think the important bit is the comment around what relevant considerations are when deciding whether to hold a fact-finding hearing. So important to keep these in mind when you've got a case. So the nature of the allegations and the extent to which those allegations are likely to be relevant to the making of a child arrangements order. That the purpose of the fact-finding hearing is to allow an assessment of the risks of the child and the impact of any abuse on the child. Whether the fact-finding hearing is necessary or whether other evidence will suffice, and whether the fact-finding is proportionate. Importantly, the court said that it's not for the court to resolve issues between the parties relating to their time together, unless to do so is likely to be necessary for and proportionate to the resolution of a dispute relating to the protection and the welfare of the child. So the judgment reiterated that the fact-finding hearing should not be directed in every case with allegations of domestic abuse. There's a duty on the court to limit fact-finding hearings to only those matters, to only those factual matters likely to be relevant to deciding whether to make a child arrangements order, and if so, on what terms. I think for some, there seemed to be a move away from fact-finding hearings with this judgment. It brings me on to the next case I want to talk about, which is Re B&B. This is quite a useful case when thinking about how to deal with allegations of domestic abuse. And in brief, the case suggests that we should be dealing with allegations in clusters. The background of the case is that it's a judgment in respect of a 5-day fact-finding hearing for following proceedings that have been remitted by the Court of Appeal in REHN. There were cross allegations of control and coercion made by mother and father, and ultimately it was mother's allegations that were made out on balance of probabilities, while father's were not. It was a case that originally predated REHN, and the parties had set out their allegations in the Scott schedules. For this hearing, the case was presented by counsel on the basis that the judge should consider the issues in a holistic way, considering the patterns of behaviour of both parties during the length of the relationship. There are two aspects that are quite useful in this judgment. The first is the judge highlighting good practice, and there are quite a number of them, so I'm only going to pick out a few because we don't have enough time, but it talks about the clusters dealing with evidence that went to issues of physical abuse, sexual abuse, emotional abuse, financial abuse, and so on in clusters. And looking at the evidence by reference to different forms of alleged abuse, a picture can be built up of the nature of relationship under scrutiny, and it's easier to see where the patterns of behaviour emerge. That's not so apparent if matters are looked at by reference of an individual freestanding items in a Scotch schedule. And I think the paragraph about understanding abusive relationships is quite useful. So, an abusive relationship is invariably a complex one in which the abused partner becomes caught up in a whirl of abuse, losing objective sense of what it was and is acceptable in a relationship. So, as well as this good practice that the judgment highlights, the judgment also highlights a list of helpful principles. And again, they are quite vast, so I'm only going to pick out a few. But I think it's helpful when we're advising clients about how judges determine the issues in these kind of cases. So I would recommend looking at it if you're in that situation with a client. Just a few of them, picking them out. The courts can have regard to the inherent probabilities of events or occurrences. Findings of facts in these cases must be based on evidence, including inferences that can be properly drawn from the evidence and not on speculation or suspicion. The court must consider and take into account all the evidence available. The judge's role is to survey the evidence on a wide canvas, considering each piece of evidence in the context of other evidence. And the judge must have regard to the relevance of each piece of evidence to the other evidence. Moving on to the next case, AA and BB. This was a case where the judge allowed an appeal dealing with the number of allegations to be investigated and the scope of the evidence to be relied on at the fact-finding hearing. The background of the case is that the parents had each applied for a child arrangements order. Directions were made pre-HN in August 2020 for schedules limited to 5 allegations, and mother's statement exceeded that. At the fact-finding hearing, the father sought to restrict mother's allegations, and mother sought to reduce evidence from a nanny and maternal grandmother, as well as exceeding the 5 allegations. Mother appealed the trial judge's decision to limit her allegations and exclude some of her evidence, and her appeal was allowed. The judge in this case commented that there will be occasions when a judge refuses to admit relevant evidence produced at the last minute, but in this case, because of the significance of the allegations of the evidence, and because the hearing was going to be adjourned anyway, the court felt that that it was appropriate to allow the appeal. Directions were given for mother to file a fresh narrative statement setting out the factual matters on which she relied, including allegations of a pattern of violent, abusive or controlling behaviour, and father was to reply with any allegations that he wished to make. I think this case is quite helpful in terms of highlighting the tension between allowing allegations of domestic abuse to be raised and not in a way that doesn't unduly limit parents, with the need of avoiding extremely lengthy fact-finding hearings. And I think we often have cases like this where a parent wants to, understandably wants to raise a lot of allegations. In the final paragraph of the judgment, it refers to the President's guidance in the road ahead and the need for this radical reduction of the amount of time the court affords to each hearing. Parties should expect the issues to be limited only to those which is necessary to determine to dispose the case, and for oral evidence or oral submissions to be cut down only to that which is necessary. And again, I think that's quite useful to highlight to a client to try and manage their expectations. Lastly, in this section, I'm going to talk about this guidance that was published in May. It's guidance published by Sir Andrew McFarlane, and it's aimed at judges and magistrates, but it's useful for practitioners to have a look at as well. It sets out the practical steps the court and the parties should take when determining whether fact-finding hearing is required, and if so, the appropriate case management directions. And it's quite a short document, so it's worth having a look at it in full. Again, I'm just going to, for time, I'm just going to pull out a few of the guidance. And it says that it's for the court to decide whether a fact-finding hearing is needed. So a reminder that it's not for parties or CAFCAS to make that decision, it's for the court to make that decision. It's not appropriate to litigate allegations of domestic abuse unless it's necessary for a decision about a child's welfare. The court should consider whether the information before it contains sufficient detail to avoid directing further evidence or documentation to determine any domestic abuse allegations. So I focus really on documents at an initial stage and what the allegations are at that point, and whether there really does need to be a fact-finding hearing, or whether there's enough evidence in the case already. If further evidence or documentation is required, the court should consider what is necessary in the circumstances of the case. It goes on to talk about this distinction between Scott schedules and statements. And it says that allegations that can be clearly defined, so for example, physical abuse, may be suitable for presentation in a set schedule. Other allegations that require the court to take a broader overview and look at patterns of behaviour, such as coercive and controlling behaviour, are more likely to require a statement. And it might be that there should be a hybrid of the two, dividing types of abuse into clusters to provide an overview of the allegations in the case. And a reminder that the court only needs to determine allegations of such behaviour to the extent that it is relevant and necessary to determine issues about a child's future welfare. And even then, that the court is only required to assess the overarching issue rather than every single factual allegation that may be raised. Again, I think quite a good reminder for clients. In that same vein, the court should consider whether the allegations go to safeguarding in general or to circumstances that could be mitigated by supervising contact or other measures. If the allegations would not be relevant to the welfare decision, no fact-finding hearing should be required. I think this guidance is quite helpful. It's quite helpful to give practitioners a clearer guide on when the court is likely to direct a fact-finding hearing, and also useful when you are advising your client about what to expect. There is a sense from some, I think, that it's becoming harder, and it's now harder for fact-finding hearings to be directed. But I think in any event, this guidance highlights the need for a focus on an early stage of evidencing why the abuse and the behaviour impacts the children, getting your case exactly where you want to be, your evidence where you want it to be at an early stage, if you do want a fact-finding hearing, so that you can be persuading the court that is actually necessary and appropriate in the case. Right, I'm going to now move over to Rose to talk about COVID and its legacy for family lawyers.
Thank you, Amy. So, COVID and its legacy for family lawyers then, what are the key issues at the moment? Well, I think all practitioners can probably agree that the courts now more than ever are in crisis. There are significant waits for hearings, which obviously makes options like arbitration much more attractive where that is going to be possible to resolve your case. And there's, in particular, I think, different policies and approaches across the country between courts as to when hearings take place in person or remotely, often for us practitioners resulting in last-minute confusion and uncertainty and difficulties for clients. I think what we've seen coming out of COVID is a sense of having to adapt to practicalities of managing contact, in particular where it's supervised or where you have international families. Clearly, the pandemic required a degree of adaptation, and whilst most borders are open, some do remain closed and some still have quite strict entry requirements. I think what we've also seen is a flexibility of the court in viewing the use of how people connect and how relationships are maintained. And that's really clear from the case of YP, which is a very interesting step-parent adoption case of an 18-year-old. And the family unit in that case was not a conventional family unit. YP's mother and the prospective adopter, his stepfather, were not in a relationship together, but they formed a family unit. Now, in that case, YP and his mother actually lived in Switzerland, where YP went to school, and his stepfather lived primarily in London, but also had a flat in Switzerland. They spent lots of time together during holidays, staying various places overseas and in London. And ultimately, YP saw his stepfather's home in London as his home. Now, the criteria in section 42(3) of the Adoption and Children Act 2002 requires the child to have his home with the applicant in the preceding 6 months. Now, in practice, YP had been at school in Switzerland and because of COVID couldn't actually come to England. But ultimately, the judge was satisfied that how we construe a home should be construed flexibly. And she made particular comments on the use of instant communication, such as WhatsApp and video calls, to help develop and maintain a relationship. And I think that's something we'll continue to see going forward from the courts. COVID has obviously had an element of bringing us all up to speed with newer technology, and that's impacted on clients' ability to participate in proceedings internationally through remote participation being a great benefit and progress made during the pandemic. And I think that's reflected in a comment Mr. Justice Cobb made in C, which was an abduction case, where he noted that there was little prejudice to the Polish court process for the mother to take place remotely. And if the Polish court formed the view that they wanted the child to return, then they could order her to do so. And it was very clear that it was expected she would be able to participate in those proceedings remotely. We've also seen the issue of stranding of families affecting the ability of people to participate in proceedings. Now, JC and PC is an interesting case in which the mother had travelled to Brazil with the children. Now, there was a dispute between the parents as to whether that was intended to be a trip or whether it was intended to be permanent. What happened is after the mother arrived in Brazil, the pandemic ensued, and she was effectively stranded with the children in Brazil, regardless of what the purpose of the trip had been. Now, the father sought the return of the children pursuant to the 1980 Hague Convention, but the timescale of those proceedings in Brazil means that they can take several years. And the Brazilian court had exercised an interim jurisdiction to make interim orders based on the children being present in the jurisdiction. And so the father subsequently issued English proceedings on the basis that England or Wales was still where the children were habitually resident because they had been stranded in Brazil. And the court was satisfied ultimately that they were, and it was not overreaching the jurisdiction of Brazil to make orders in relation to the children. So turning then to developments in surrogacy and ART, there are a couple of areas I'm going to talk about and some key cases and learning points that I'll highlight, which are relevant to any practitioner, even if you don't specialise in this area. Now, I think you couldn't talk about surrogacy at the moment without talking about Ukraine and the tragic events that have happened there with the outbreak of war. Now, prior to the war, Ukraine was a very popular destination for married heterosexual couples. That's both in terms of the legal framework in Ukraine, because under Ukrainian law, a surrogate is not a legal parent, only the intended parents are, but also the wider availability of surrogates and relatively low cost compared to other jurisdictions. Now, when war broke out, there was an immediate problem and reports of surrogates and newborns being trapped in Ukraine, with intended parents simply unable to get into Ukraine to collect their children or to assist the surrogate. Now, this also led to issues with difficulties around birth registration for those children in Ukraine to be able to then get travel documents, because the surrogate is not a legal parent in Ukraine and wasn't able to register their births. Fortunately, the UK government did subsequently confirm that 3-year emergency visas would be available for surrogates to UK-based parents and their immediate family. 7 months on from the outbreak of war, we're now approaching the time when, in a few months, there won't be issues around surrogates or newborns in Ukraine being trapped, because simply time has marched on from when those arrangements might have been put in place. But many couples will still have gametes stored in Ukraine, whether eggs, sperm, or embryos. And there are very strict rules surrounding importation of gametes into the UK. And it's very unlikely that intended parents will actually be able to import those gametes where a donor has been used because of the UK regulations. And so I think we're probably likely to see issues around where those gametes can actually be transported to. I think the question that then raises in my mind is, where next for the surrogacy industry? We've seen in the past with the closure of the surrogacy industry in countries such as Thailand that the industry simply moves to another destination and starts to run from there. I think as we move to a post-COVID world, we can expect to see a greater increase in surrogacy arrangements starting up again, and new and emerging destinations, some of which the legal framework may not be particularly clear. Which brings me on to the issue of the lack of cross-border recognition of legal parentage. And this is a real recurring theme in case law that we're seeing at the moment, that parents are innocently unaware that there is no cross-border recognition of legal parentage conferred through surrogacy. And there are two cases that really quite starkly show the potential consequences of this. The first is X, Y, and Z. Now, this was a case involving a married same-sex couple who lived in Denmark, one of whom was a Danish citizen. Now, they had twins through a surrogacy arrangement in Oregon, and subsequently had a further child through a surrogacy arrangement in California. They went through the relevant legal processes in those jurisdictions, Oregon and California, to be recognised as legal parents, and returned with them to Denmark. After the twins were born, they were registered as Danish citizens based on one of the father's legal parentage. However, when they tried to register their third child as a Danish citizen, they were told, in fact, the twins had been registered as Danish citizens in error, and only the biological father, who was not a Danish citizen, and the surrogate could be recognised as legal parents in Denmark. To make matters worse, and I think really highlights the stark issues for children and intended parents, the Danish authorities then actually threatened to deport the children from Denmark. And so the family was suddenly in a state where they were told that, in fact, the legal parentage they had secured in the USA was not recognised in Denmark, and where they were faced with the very difficult issue of whether or not their children were going to be deported from the country. The family applied for parental orders in England and permanently relocated to this jurisdiction. Those parental orders confer legal parentage in this jurisdiction, but they would not be recognised in Denmark. The court was ultimately satisfied that although these applications for parental orders had been brought outside the 6-month time limit within the legislation, it was going to be in the children's best interests to grant the parental orders. The parents had been entirely unaware of the need to apply for a parental order and had acted in good faith, believing their status as parents under US law would be recognised in Denmark, where they were living. And as soon as they became aware of the issues and became aware that they would be able to apply for parental orders in England, they had done so. And the second case dealing with the lack of any cross-border recognition is re X and Z. Now, this was a married couple who lived in England, who entered into a surrogacy arrangement in California and obtained the relevant pre-birth order in California, which made them legal parents. Now, their child was born in 1998, and it was only in 2021, when the child was 23, that it became apparent that they had never applied for a parental order and needed to do so. Now, the parents were entirely unaware in this case that they had needed to apply for a parental order in this jurisdiction. And I think that's an important reminder for us as trusted advisors. We need to check with our clients how their children were born, because it may impact upon our advice to them. And this was a case where the parents had always been very open with their child that he was conceived through surrogacy, but no one had ever in their lives questioned the lack of a parental order. Everybody had worked on the basis of the US birth certificate, but that didn't confer parentage here. In fact, it was only when the couple were told by their surrogate, who was acting at that point as a surrogate for another English couple, that they became aware that they needed a parental order. Now, clearly, the application was outside the 6 months time limit, and the court was satisfied again. This was a case of good faith and unintended awareness and should be extended. The interesting thing about this case is that there's no express provision in the HFEA 2008 preventing an application being made in relation to an adult child. And that's quite in stark contrast to adoption legislation, where there is express provision that you cannot make an order in relation to an adult child. And as soon as the child becomes 19, the court cannot make an order. One further issue arose in this case, which was about the interpretation of home again. And the reality was that the 23-year-old child no longer lived in his parents' home full time. The court was satisfied that they should interpret home in a broad and purposeful way, emphasising the close relationship of the family, and that they still remained as one family unit, with the child spending time at his parents' house, even if that was not his permanent address. And so moving on then to posthumous parental orders. Re-ex is the first example we see where the court has made a posthumous parental order in relation to an unmarried couple where one of the intended parents had died prior to the application being made. And I think, again, this highlights for me what is a problem with our current system in relation to parental orders, that applications can't be made until a child is born. And so, sadly, situations do arise where applications have to be brought after a child has been born, but one parent has already died. Now, in this case, the court was satisfied it was appropriate to read down the legislation by reference to the HRA 1998 lens to permit the application on the basis that prior to the intended father's death, the statutory requirements were met. And they were that the conception had taken place via ART and the gametes of one of the applicants had been used, in this case, the intended father's sperm. The court was further satisfied that, but for his death, the criteria that the family was in an enduring family relationship would have been met at the time of the application, and the child had his home with the surviving parent, and so the court made the order. Now, this brings me on to what is quite an unusual known donor case, and I think it's really important to emphasise that McDougall is very fact specific. And what's interesting about McDougall is that the sperm donor, James McDougall, had advertised his services as a sperm donor online, but knew that he had an inheritable genetic condition that would in fact have prevented him from donating through a fertility clinic. Now, he took no real steps to explain this condition to the mothers, and they didn't really understand, although there was a reference to Fragile X being made. Subsequently, James McDougall applied to spend time with two of the children who had been born and for parental responsibility in relation to them. Now, although he had had a relationship with one of the children prior to the relationship with that between him and that mother breaking down, the court ultimately refused any form of contact and parental responsibility, and the court expressly considered whether even letterbox contact was appropriate and decided it was not. And I think for me, that's what's really unusual about this case. And it's important to remember that this is this was a decision that was made based on very fact-specific findings around James McDougall's motivation, which the court found was one of control. And what the court found was a complete lack of insight by him into the impact that his actions were having on the mothers and the harm that would cause for children. So I think this can't be taken at all as an example of sperm donors won't get contact or parental responsibility for children that they are legal parents of. I think what this is an example of is some of the problems with known donation, where people have met online and entered into arrangements that aren't regulated. And that's a particular problem for unmarried couples or single women, because unless they conceive at a UK licensed fertility clinic, then the donor will be the legal father of their child. Now, I think what's also interesting about this case is that the court imposed a Section 19114 order for 3 years, despite there being no history of repeat applications, which again was based on findings that James McDougall had told the Guardian he was going to continue to make applications until he got what he wanted. And the court ultimately considered it was in the wider public interest to name him in the judgment, in particular considering that there was a concern he might act as a donor in the future, and if he was named in a court judgment, then hopefully others who were considering using his donation services might look him up on the internet and find the judgment and see what had been said about him. And then lastly, this brings me on to Sarah Osborne on Helen Arnold, which is a case of a birth registrar simply getting things wrong. Now, this was a same-sex couple who conceived their children through IVF treatment at a UK licensed fertility clinic. They signed all of the appropriate consent forms, and so the second female parent was a legal parent of the children. Unfortunately, when they went to register the birth of their first child, they were wrongly told by the registrar that she couldn't be registered on the birth certificate and she would have to apply to adopt her child. She in fact did so, and what's quite stark really is that no one, not just the local authority who were involved in the adoption application or the court, ever picked up that in fact there was no need for an adoption because this woman was a legal parent. And it was in fact only when the couple went to register the birth of their second child that they were told they had been given the completely wrong information in 2014. Now, whilst it was possible to re-register the child's birth, adopted was always going to appear on the official record if that happened. And so to put the couple in the same position they would have been, but for the registrar's mistake, the court used the inherent jurisdiction to revoke the adoption order and judicial review to quash the original birth registration. This is evidence of sort of a fairly highly exceptional case in which courts will revoke adoption orders. And so I'll move now on to Zoe, who is going to talk to you about parental alienation.
Thank you, Rose. I'll just share my screen. Right. Yes, hopefully you can see my parental alienation slides. Let's just. Okay, I'm going to look at two judgments of A and B and re-A and B, both from January of this year. They're both very long judgments. First one's 52 pages, the second one's 73 pages. I've quoted quite heavily from them in my slides, and I'm going to run through these slides given the time we've got today. The first case of A and B is a private law case. It's always very fascinating to me the circumstances in which a child becomes alienated. In this case, the parents separated. There was a marital breakdown in the summer of 2020 due to mother's extramarital affair. By the end of the summer, the children were living with father, and the mother issued her child arrangements order application in September 2020. Throughout the next year, social services were involved, and a psychologist, Dr. S, assessed the children. The things that the children were saying were things like, mummy left us, mummy left the family. The father's accusations were that mother's behaviour was erratic, unpredictable, and he diagnosed her as having bipolar, but no expert made such diagnosis. So a typically sad case, and the outcome, which is set out there, was that the judge in January this year, Recorder Moyes, decided that the children were to live with mother in circumstances in which the father was alienating the children, and the move was to be gradual and guided by expert input. The judgment found that the father's hostility towards the mother had driven him ultimately to restrict the children's contact with mother, then stop it altogether in spite of there being no justifiable reason. Father's contention that he had reasonable excuse for not complying with child arrangements order due to, he said, the children's strongly held wishes was rejected, and he was found to be in clear breach of terms of the orders. Just latching on to the second bullet point on that slide, father in fact wrongfully removed the children to Australia in December 2021, just prior to the final hearing in January 2022. He notified the children that he would be returning on the 8th of January, but in fact remained in Australia during the final hearing. At the time of the final hearing, the mother had issued 1980 Hague Convention proceedings in Australia, but directions for those were yet to be listed. Both a social worker and a therapist had worked with the family, finding that father was alienating the children from mother, who was a child-focused and loving parent, quite capable of meeting their needs. There's quite a lot of detail in the judgment about father's partial engagement with the final hearing, and a very careful judgment as to how the judge was able to proceed in the absence of father's cooperation. So orders were made in his absence when he didn't attend at the final days of the hearing. The outcome was that the children were to live with mum, not to be implemented until the court had approved a plan for transition. The parties were to instruct a psychodynamic psychotherapist and systemic family therapist to give information to the court how to best implement the change of residence. We'll see in the next case I look at that there's reliance on this specialist therapy to support the family, local authority involvement to prepare a Section 37 report, prohibited steps order preventing either parent from discussing the transfer of residence with the children until there was agreed schedule of action, and there was a penal notice attached to that prohibited steps order. And then the father there were findings against the father, which included that he had caused the children's unjustified rejection of the mother and was alienating them from her. The court relied upon the Kafka's definition of alienation, which there's a 6-point Kafka's definition, which I'll just briefly set out the first 3 points here. They are in paragraph 49 of the judgment. So one, while there is no single definition, parental alienation is recognised by Kafka's as involving a situation where a child's resistance or hostility towards one parent is not justified and is the result of psychological manipulation by the other parent. Alienating behaviours present themselves on a spectrum with varying impact on individual children, and this requires a nuanced and holistic assessment. We'll look at the reliance on expert evidence in a moment. Both men and women can demonstrate alienating behaviours. While alienation can be demonstrated solely by one parent, it is often a combination of child and adult behaviours and attitudes, with both parents playing a role, that lead to the child rejecting or resisting spending time with one parent. Of interest to me in this case, Dr. S, the psychologist, found that mother could be passive in relation to certain situations, and that was something to be worked on with regard to the transition to her care. So the judge said, oh, that's a comment on general positions. I'm not going to read that out. Staying the domestic proceedings, the judge found that she wasn't going to stay the final hearing in January of this year, despite Hague proceedings being afoot in Australia. Again, she deals with in detail about how she managed to conclude the matter with the father's lack of engagement. That's a comment which I'm not going to read about her observations of the father's evasive evidence. And again, there's the judge concluding that even if this did not start with a campaign to alienate the mother from the children, I find that the father's behaviour has evolved into one such that he is now making a concerted, calculated and deliberate effort to erode the mother from the children's lives. I mean, it couldn't have got more serious than him wrongfully removing the children in the context of domestic proceedings to Australia and not giving an address to the court. So those are the findings of the judge about the father's emotionally abusive conduct, causing the children significant emotional harm. And the conclusion in the second bullet point on that slide is that if children are allowed to grow up believing that their mother is an abusive parent who does not love them, then this is likely to have a seriously deleterious impact on their future relationships with peers and partners as they grow older, and to prevent them from developing into emotionally and well-adjusted adults. So moving on to the next case, which again, a January 2022 judgment. This is a public law case. The theme that continues is the readiness of the reliance of the court on psychologists. And again, this is an alienating father. What's unusual about this is the father was in fact only having weekend staying contact. He'd been extremely abusive and violent within the marriage. They separated. He was just having weekend staying contact. After a further incident of abuse, the mother got an injunction and stopped contact. The children, at the behest of the father, just left their mother's home, went to live with the father, and then refused to have anything further to do with their mother. This was an really extreme case of alienation, I think, through fear inculcated in the children, in contrast to the previous case we looked at where the children were saying, well, mummy left the family, mummy broke the family. This was clear fear from the children of their father. So the outcome was that there was a final care order and the children had to remain in long-term foster care, separate from one another and having no contact with either parent. So there couldn't be a more extreme outcome. The judge set out the therapeutic interventions necessary, reliance on Melanie Gill's psychologist. So there were recommendations for video interactive guidance for both parents, EMDR for mother, eye movement desensitization and reprocessing for her to deal with the trauma she'd experienced. And then the mother may in time make an application to discharge the care order and have the children back to live with her once she'd made progress with her therapy. Given the time, I'm not going to say anything more about that case, but I have summarised the conclusion on that slide. Before I finish this topic, I'm just going to briefly touch on the recommendations in the President's Memorandum on experts in the family court. For those practitioners listening, you're aware of the controversy around experts around parental alienation, and it's worth looking at that memorandum. And in these two cases of January this year, there was a psychologist, Dr. S, in the first case. There was Melanie Gill, a psychologist, in the second case, and it sets out the circumstances in which the judge was able to rely on that expert evidence, given that it was based on a background of research. Thank you. I'm now going to pass to Amy and just stop sharing my screen.
Thank you, Zoe. So let me just share my screen and get to where I need to go. Right, so in this section, I'm going to be talking about section 9114, orders and transparency, starting off with section 9114, orders. And in brief, this with section 9114 orders, I think there's now a move towards using these kind of orders more regularly as a protective filter. So the first I'm going to talk about this case, a child In brief, it's the Court of Appeal clarifying and broadening the parameters for employment of such orders. The background of the case is that the court made findings that mother had deliberately frustrated the relationship between the child and father. She'd made wholly unfounded allegations of sexual abuse and other serious allegations of father, and there were assessments were carried out of mother and child. She was assessed to have a personality disturbance that meant that she was subjecting the child to maltreatment without being aware of the impact on the child, and treatment was recommended, although the prognosis was pessimistic given mother's lack of insight. Importantly, I think in this case, the mother had made multiple complaints against professionals and experts. She sent a large volume of correspondence to the father and continued to complain about father's care of the child throughout the proceedings. And as a result of that, I think, and her conduct within the proceedings, the judge ordered that there should be a Section 9114 order for a period of 2 years. The judge ordered that the child should live with father and mother should have professionally supervised contact with the child. Mother appealed on the basis that she said an order for supervised contact as well as a Section 9114 order would not allow the progression to unsupervised contact unless she undertook the therapy recommended by the psychologist. Her appeal was dismissed, and the court found that it's not wrong in principle to make a Section 9114 order and an order for supervised contact. And in the judgment, the court revisited the guidance on making Section 9114 orders, which is set out in the case of BP. In that case, in summary, the guidelines provided that Section 9114 orders should only be made with great care and sparingly and as a weapon of last resort in cases of repeated and unreasonable application or where the welfare of the child requires it. In this judgment, Lady Justice King acknowledged that REP is now some 22 years old, that the forensic landscape has changed. Beyond all recognition, we now have smartphones, we have social media in all its forms, we have email that provides instant communication, and we also have the withdrawal of legal aid, which means that often parents don't have the steadying influence of legal advisors. The judgment comments that the judges may be bombarded by emails, and sometimes those emails are from parents who are anxious, but on other occasions it's as part of a campaign of behaviour by one parent against the other, which amounts to a deeply disturbing form of oppressive behaviour. I think this judgment highlights those cases where the judge is of the view that the type of behaviour by one parent amounts to what is called in this judgment lawfare, so the use of the proceedings as a weapon of conflict. And in those cases, they are more likely to warrant an order under Section 9114. I think this judgment highlights that the overall conduct of a party is more relevant when making these orders. And as I said at the start, there's a move towards these orders being used more regularly as a protective filter. This then leads on to the change in the law. Section 67 of the Domestic Abuse Act 2021 amends Section 91A of the Children Act. In brief, this change to the law brings clarity about when Section 9114 orders should be used. So if you're in that territory, do have a look at it. It came into force in May, and it states that the court may make such an order where it is satisfied that the making of an application would put the child concerned or another individual at risk of harm. And these orders can be made by the court of its own motion or by an application by the relevant individual on behalf of the child concerned or any other person who is a party to the application. It comes with a practice direction 12Q, so again worth having a look at that if this becomes relevant in one of your cases. This change in the law clarifies that Section 9114 orders are available to parents and children to protect them where further proceedings would risk causing them harm, in particular where proceedings could be a form of continuing domestic abuse, so widening the circumstances where such orders are appropriate. Moving on to transparency. So I couldn't talk about transparency without talking about Andrew McFarlane's report in October last year. And this report, as I'm sure we all know, talks about how there should be a major shift in culture and process to increase the transparency of the system. However, the report does stress that it shouldn't come at the expense of the interests of children subject to proceedings, and it it states that changes that are envisaged for the future are subject to the proviso that the anonymity of individual children needs to be preserved. The court and practitioners must, when considering greater openness in proceedings, have firmly in mind the competing interests commonly in play when balancing freedom of expression against the child's right to family life and privacy. The report sets out a number of changes that have already begun, and some of that they're in the process of being implemented, including accredited media representatives and legal bloggers not only being able to attend and observe family proceedings, but being able to report publicly on what they see and hear, but that this reporting must be subject to very clear rules to maintain anonymity of the children and family members and confidentiality with respect to intimate details of their private lives. The default position being that journalists will not only be prohibited from identifying the child, but also publishing any identifying data such as school locality and from publishing detailed evidence of abuse. Lastly, in this section, just wanted to mention Griffith and Tickle, which is rather unusual case, but in brief, it is a case where the judgments relating to those proceedings were published on public interest ground, the names of the parties made public. It's an unusual case and it involves a former MP and an MP, and it was the father's appeal against the decision to allow publication of the fact-finding judgment, including naming both parents and only including modest redactions aimed to provide protection of the subject child. The fact-finding judgment gave details of father's behaviour, who was found to be controlling, coercive, financially abusive, and to have raped mother. Interestingly, I think this was an application brought by the accredited media representatives, which was supported by mother, and in due course and importantly supported by the Guardian and also the interveners, which were the rights of women. As I say, this case is quite fact specific. The parents were both public figures and in public office. Some information about father's behaviour and the response to it was already in the public domain, and he had already issued information about himself, which later transpired to be false and misleading, and the child was also very young. The court said that in deciding to publish this judgment, the critical factors that weighed in favour were father's decision not to rely on his own Article 8 rights, only the child's young age, the Guardian's professional assessment and support of publication, mother's support for publication, and the information that father had already put out in the public domain. So I think reassuringly, we can reassure our clients that in most cases judgments will be published anonymously. However, this case shows that when asked to decide a dispute about publication of a judgment, the court will consider the specific facts of the case and the competing rights of private and family life with freedom of expression and public interest. Right, I'm now going to stop sharing my screen and hand over to Zoe for the final section.
Thank you, Amy. While I just share my screen, I'm just going to make a comment about what you were saying about transparency. And I know that the Family Justice Young Persons Board, the FJYPB, have been quite vocal, because those are, for those who don't know, the FJYPB is a group of young people who have been through the family justice process, and they've got some great worksheets on what about me and what they think are good tips for practitioners. But they've also been quite vocal, because a number of those young people have been subject to anonymous judgments, and they're saying you've got to be a bit more careful. They're a bit horrified that there's so much detail about them being shared in what are anonymous judgments, which they feel that they're recognisable in. So that's something else to keep an eye on. Right, conduct of hate cases. I have 5 really helpful practical judgments to get through in 5 minutes. I'm going to skip through some more quickly than others. The theme that I'm going to propose of these 5 cases is that on the one hand, there's a tension between judges getting frustrated with the volume of evidence that comes before them and reminding practitioners that these are summary proceedings, but also judges saying, well, it's quite helpful to have contemporaneous emails and WhatsApp, because it helps me determine what was really going on. So there's that tension, but also I would propose that there's a theme of greater exploration of an Article 13B defence of risk of grave harm and intolerability. So let's first of all start with ES and LS. In this case, the father was seeking the return of the parties' 2 children from England to Latvia. Following their separation, mother met a new partner who's based in England. She came to England in December 2019 with both children, and they remained living in the UK since that date with mother's new partner. Father said he wasn't notified, while mother said he had given his consent. Father took no action until March 2021, when he commenced a welfare application in Latvia, and then also made an application pursuant to the convention, which first came before the court without notice, in which father sought a location order. Given that it was 12 months after the children's arrival, mother was able to argue an Article 12 settlement defence. So she relied on the defence of settlement under Article 12, the children's objections under Article 13, consent and acquiescence under Article 13A, and risk and intolerability under Article 13B. Mr. Justice Mostyn was clear that the children had settled, and having established settlement, he didn't need to go on to consider mother's other defences. In relation to the settlement argument, the family court advisor who saw them in July 2021 was satisfied that the children were happy and settled. Remember, they're 14.5 and 12. The children's objections were valid and authentic, and they'd reached Gillett competence. Accordingly, had it been necessary to rely upon the child's objections, the judge found that no return order would have made on that ground, as well as settlement. So yes, Mr. Justice Mostyn was at pains to remind practitioners Hague Convention proceedings are a summary process, complained about these proceedings monopolising disproportionate amount of court's time, and in this case the father wanted to cross-examine a Kafkas officer, and the middle bullet point is that the judge said procedural fairness ordinarily requires parties to be able to confront in cross-examination a Kafkas officer who has given evidence adverse to that party. Not so in proceedings that are summary, procedural and interim in nature. Again, the father was criticised for making a without notice application, and I think there was a finding that father was disingenuous in his application of March 2021 when he suggested he didn't know the mother's address. The middle bullet point is reference to the date upon which the family court advisor assessed that the children were settled. The father's application was March 2021, and the father and the children saw the family court advisor in July 2021. The father advised that settlement should be assessed as of March 2021. So the father's argument was that where they settled now was then in March 2021, whereas the court found that settlement was assessed as by the Kafkas officer in July 2021. Moving on to C. In this case, this was a rehearing of father's application for a return order. Mother was Polish and maintained her Article 13B defences on the grounds of risk and intolerability to the child and mother should they be ordered to return, and the child's objections. Mother accepted that she had wrongfully removed the child from Poland. What was helpful in this case is that mother recorded some of the contact between the child and the father, and father was heard making quite vile threats, both about mother and child, and this was having given an undertaking that he wouldn't be threatening or abusive. There was also an unfavourable report about father within the domestic proceedings in Poland. So this case is a helpful case as to how closely the court inspected the Article 13B defence as to mother's allegations of domestic abuse. And although in the first instance, in the domestic case in Poland, mother didn't make the allegations of domestic abuse, she did refer to the father's abusive behaviour towards the child. It was found that the fact that she'd made no allegations of abuse, either as to the seriousness of his conduct in Poland, was not a problem in relation to the Hague proceedings in this jurisdiction. Judges are getting much more astute at recognising that individuals don't necessarily recognise they're a victim of abuse initially, or the fact of its relevance or importance to mention it. But for us practitioners, it's helpful to ensure that we get that evidence from our clients if it's there. Just be mindful of clients' different experiences and ability to share relevant information. The next case, I think I'm going to rattle through this one because it's quite a short case. It was a Russian case. Father brought the 5-year-old here for summer. Mother said he brought here for summer. He produced a document saying that mother had given consent for the child to stay here for a longer period of time. Again, this is the case where there was a lot of evidence. Both parties produced, so Mr. Justice Peel, first bullet point here, was appalled by the sheer weight of documentation for what is supposed to be summary proceedings. So both parents produced reams of emails, WhatsApp, text messages, and it's interesting, both parents edited what they produced to make it more favourable to them. So whilst at the same time complaining about the volume of the material, the judge does say that in this second bullet point, contemporaneous documentation of this nature is likely to be the most valuable evidence. So that's helpful. Conscious I've gone over H&B. This was a very interesting French case, and it's an Article 13b defence. And in this case, the mother's Article 13b defence was successful. She'd suffered significant mental health episodes, and the court found that an order for return would subject the child to physical or psychological harm, or otherwise place him in an intolerable situation. And there was a psychiatric assessment of Dr. Sumi Ratnam, and it was clear that mother had suffered from long-standing depression, which mother said was alleged was due to a long-standing pattern of abusive behaviour by father. So I think that's relevant for any Article 13b defences you're going to be running. Final case. Again, it's an Article 13b defence case. I think given the time, I'm not going to, I've included quite a lot of detail on the slides, which you're going to get, so you can read that to yourself. I know you'll read every page that we send you. But again, there was reliant upon expert psychological health report about mother's mental health and the Article 13b defence. So that's a summary. I'm sorry I've just not dealt with the last two cases in great detail, but I'm mindful of the time. So I'm going to stop sharing my screen. And just in conclusion, because we've run over, I'm not going to deal with any questions, and I just want to do a bit of housekeeping before we finish. I want to thank everyone for joining us. We've really enjoyed our Child Law Awareness Week this week at Mills Reeve. As you leave, there'll be a feedback form that will pop up, and I'd be really grateful if you could complete that. Thank you so much for joining us.